We've got some huge news coming out of the state of New York. Once again, a transformed conservative court system is stepping up and protecting Second Amendment rights. We're going to see the latest decision that has officially struck down so-called red flag laws. We're going to see how that decision will doom such laws throughout the nation. And make sure to stick with me at the very end of this video when we'll find out exactly what all of this means for the future of woke, gun-grabbing liberals. You're not going to want to miss this. A New York State Supreme Court judge has struck down the state's draconian gun confiscation law as blatantly unconstitutional. ERPO, which stands for Extreme Risk Protection Orders, was the latest attempt by New York liberals at enacting so-called red flag laws. Red flag laws allow the government to seize firearms from a person they believe possesses a threat to themselves or others, even though they haven't committed any crime. Since the law took effect back in 2019, there have been nearly 2,000 gun removal orders issued. It's a radically draconian law that's being used by woke leftists to incrementally disarm the population throughout blue states. Blue states that have a large gun control contingency in their state legislatures. That's not all blue states, right? Delaware, Vermont, there are some others that are solidly blue, but also very, very pro-gun rights. And that's why this is a huge loser for the woke left. The gun enthusiast culture extends way beyond red states or conservative counties. It's actually a very, very diverse community. But regardless, this judge in New York has officially struck down this red flag law as blatantly unconstitutional. State Supreme Court Justice Thomas Moran ruled that the ERPO law violated the Second Amendment as well as the 14th Amendment, the latter because it doesn't sufficiently protect a citizen's rights. The 14th Amendment expressly forbids any state from making or enforcing any law which abridges their rights as citizens of the United States. Now, this ruling comes on the heels of the Supreme Court's earlier ruling known as the Bruen decision, which also involved the state of New York, interestingly enough, which tried to require gun owners to show proper cause to get a license to carry a concealed handgun outside their home. Now, keep in mind, the Second Amendment clearly states that American citizens have the right to bear arms. We have a constitutional right to carry guns. But the Democrat monopoly in New York didn't think so. So SCOTUS had to step in and strike down that law as blatantly unconstitutional. It was a 6-3 ruling. And the court found that New York's restrictions on obtaining a concealed carry license were unconstitutionally restrictive. Surprise, surprise. The court agreed that the only person, according to the Second Amendment, the only human being on the planet that should decide what the proper cause is for carrying a concealed weapon is the person carrying that weapon, the person bearing it. That's what shall not be infringed actually means. And this judge in New York, in this latest decision a couple of days back, cited the Bruen case several times. So the Supreme Court set the clear standard that a person's right to bear arms shall not be infringed, and now we're seeing state Supreme Court justices enforcing that precedent. In other words, your constitutional rights are not subordinate to the weaponization of fear and safety. If your neighbor is concerned about his safety around you, that concern does not trump your constitutional rights. If there's a concern about you owning a weapon, that concern has to be subject to due process. Concerns about what someone might do not trump that person's constitutional rights. It seems so patently obvious, but when you're dealing with hardcore libs who hate the Constitution, then, well, this is when you need a conservative judiciary to defend those rights. And largely thanks to Donald John Trump, we've got that. President Trump appointed more federal judges in his first term than any president in 40 years. Of course, Trump appointed a record number of Supreme Court justices, giving that 6-3 majority. And he also appointed 30% of U.S. appellate judges. And so what does all of this mean, especially when it comes to the gun-grabbing agenda of the woke left? Well, let's just say what it means. You're going to love it. But first, for you Patriot owners, you Patriot business owners out there, you have got to meet my good friend Josh Zaglowski, co-founder of ERC Specialists. He's got an amazing payroll protection company exclusively dedicated to understanding and maximizing what's called the CARES Act Employee Retention Credit. That's the ERC. So if you are a small business owner looking to get up to $26,000 per employee back from bumbling Biden, click on that link in the description below to see if you qualify today. It's an absolutely amazing opportunity. What's happening in the Supreme Court and in state Supreme Courts really is nothing less than a renaissance in gun rights over the last several years. One of the most amazing developments of the last decade is the rise of what came to be known as Second Amendment sanctuaries. Since their inception during the Obama era, the vast majority of all U.S. counties have officially been designated Second Amendment sanctuaries. As of today, there are now 1,930 counties protected by Second Amendment sanctuary legislation, either at the state or county level, which represents 61% of the 3,141 counties in the nation. So nearly 2,000 of just over 3,000 counties are now officially Second Amendment sanctuaries. It's astonishing. In addition, countless sheriffs across the nation have pledged to uphold the Second Amendment, including, you'll love this, every single sheriff in the state of Utah. And this massive embracing and protecting of the Second Amendment, it goes beyond even that. We also have to remember there's a number of constitutional carry laws being enacted as well. Constitutional carry involves laws that expressly state a citizen's right to literally bear arms. There's no permit required to possess a concealed handgun. In other words, the FBI background checks when buying a gun are enough. If you could purchase a gun, you can carry the gun, period. Recently, the state of Georgia became the 25th state in the union to pass constitutional carry. That officially makes half the states solidly pro-Second Amendment in its original constitutional form. So there's no question the woke leftist attempt at confiscating firearms is, shall we say, backfiring big time. And with these latest rulings from both the federal and state Supreme Courts, that backfire ain't going away anytime soon. As always, make sure to smack that bell and subscribe button. You'll definitely want to check out my latest video on Trump for speaker exploding, all as McCarthy becomes increasingly desperate. You're not going to want to miss it. So make sure to click on that link, and I'll see you over there. God bless.